The outline and summary of this: 1. An attorney owes you nothing. 2. The moment you hire them, you become their ward, and they're not bound to listen to anything you say. Simple as that. The moment you hire them, the only thing that they're liable to do to you, for you, the burden they have regarding you, is to simply tell you, hey, you have the right to do this and the right to do that. 4. The only burden they have is to tell you that you have the right to do this and to do that, which is legal advice, is because only you can enforce your right. If you're not denying and objecting things on the record, you're screwed. If you're not showing lack of partiality, you're also screwed. Most people don't do that. And instead, what they do though is they come back talking about, hey, I gave this attorney this amount of money and I didn't get the result that I wanted. So because of that, there's an ineffective assistance of counsel. That is a verbiage that is used. Rightfully, in your mind, you gave that man or that woman thousands and thousands and tens of thousands, in some cases hundreds of thousands of dollars. And because of that, you're expecting some magic to happen. He's going to move to the next one and do the same thing. Simple as that, because he owes you nothing. An attorney is an officer of the court. When you hire them, you are deemed to be incompetent, and everything you say is dead. Simple as that. Interpreting Silla's habeas petition with the virality afforded to pro se filing. Silla appears to challenge his conviction on the basis that his trial counsel made 3 tactical errors. First, Silla contends his counsel was ineffective in advising him not to testify in his own defense. Second, Silla contends that his counsel was ineffective for not calling the witness on his behalf. Third, Silla contends his counsel was ineffective for resting at the conclusion of the government's case rather than presenting the affirmative defense. The convicted defendants claimed that counsel's assistance was so defective as to require reversal of conviction. Has 2 components. First, the defendant must show that counsel's performance was deficient. This requires showing that counsel made errors so serious that counsel was not functioning as the counsel. What determines what the counsel is? If you had presented a contract, or if whatever their definition of what they're supposed to do as lawyers and attorneys, and who their fidelity is, which is not to you, the client, guarantees the defendant by the 6th Amendment. There you go, 6th Amendment. He was supposed to bring the Constitution and he didn't do any of that. Second, the defendant must show that the deficient performance prejudiced the defense. Unless a defendant makes both showing, it cannot be said that the conviction resulted from a breakdown in the adversary process that renders the result unreliable. Then to go into details and explaining it. This test presents a high bar for defendant. Strickland instructs courts to apply a presumption of effective performance. And they go on to explain what a presumption of effective performance is. And then they're telling you this is the only thing the attorney is liable to do for you. Performance, as in contract. And then when you propose something, they accept it and they have to perform. And that's what's going on here. That's what they're telling you. And this is the presumption of what an effective performance is based on your attorney-client privilege, attorney-client relationship. It goes on to say the standard of Strickland is rigorous, and the great majority of habeas petitions that allege constitutionally ineffective counsel founder on it. Because the test is conjunctive, a habeas petition's failure to satisfy either pronged requests require that the challenge to the conviction be rejected, meaning all of them has to be satisfied. As to the first requirement, a petitioner must show that the counsel representation fell below an objective standard of reasonableness. This objective standard of reasonableness is, what are they liable to do? The court must indulge a strong presumption that a counsel's conduct fails within the wide range of reasonable professional assistance. They are liable to what their professional duties are. Actions or omissions by counsel that might be considered sound trial strategy do not constitute ineffective assistance. Meaning, what are they liable to? What they're liable to is what they're supposed to be doing in their profession. And if what they're supposed to be doing in their profession is based on what has been deemed to be a strategy, it doesn't matter what you say about it, so long as they classify it as, how they can claim trade secrets to not say certain things. Well, they can say it's part of our profession to do this certain things. That's what we usually do in our occupation. It's well known. It's undisputable. Like you bring in a mandatory judicial fact. It's undisputable. There it is right there. It's the Constitution. Everybody knows it. It goes on to say,
because courts recognize that counsels must have wide latitude in making tactical decisions. You know what this means when they say wide latitude? They can do whatever the hell they want the moment you hire them, and there's nothing you can do about it. They are your God. For this reason, strategic choices made after thorough investigation of law and facts relevant to plausible options are virtually unchallengeable. There you go, right there. You can't do anything about it. And even strategic choices made after less than complete investigation, meaning they don't ever have to put much effort into it, so long as they're saying, look, this is part of what we do in our profession, and it's well known and undisputable. Even strategic choices made less than complete investigation do not amount to ineffective assistance. So you want to come here and say, hey, this guy didn't do the right job, because usually when I hire somebody, tell them, hey, fix this for me, I'm going to pay you this, I expect you to fix it because I pay you this amount. With an attorney, a British accreditation registry member, you can pay that man $300,000. He does what he wants. Why? Because he has wide latitude to make any tactical decision based on, his professional assistance. He's the professional here, you're not. Because if you was, you wouldn't be hiring him. And of course, if you look into other case laws, unless you know you're awarded a state the moment you hire one. So long as known facts made it reasonable to believe that further investigation was unnecessary. And what are these known facts? These known facts are determined whether you did your affirmative defense, whether you objected on the record, whether you put the applicable laws, and the evidence is necessary. And guess what? Even if you hire an attorney, that's because there's different types of attorney. So say at best you found a constitutional attorney, right? There's a very good chance that they're not going to do all that. Some will, but most probably won't. Hey, I'm not telling you that you shouldn't hire an attorney. Go hire an attorney. Have your own first-hand experience, but put these things into consideration of what other people have went through, so you don't go through it. With respect to the second prong, petitioner must show a reasonable probability that, but for counsel's unprofessional errors, the result of the proceedings would have been different. Meaning, oh, this guy was unprofessional, he didn't do his job. So the first prong was, hey, based on what we're supposed to be doing, we have wide latitude and we can do anything. And you have to prove that that's not so. Petitioner must show more than unprofessional performance merely had some conceivable effect. So if you're coming and say, hey, this guy was unprofessional, you still have to prove it. But remember, they have wide latitude to make any decisions, because you hire them as the professional in the matter, so you have no say. Reasonable probability is one that undermines confidence in the outcome. If a defendant fails to show prejudice, remember I was telling you about impartiality and prejudice, about the attorney credential? There are many more ways, but that's just one of them. The court need not consider the objective reasonableness of counsel's action. In the context of decisions to testify, the right to testify is personal to the defendant and may not be waived by his attorney over the defendant's objection. Meaning your right is yours to enforce. An attorney cannot do it for you. You want to object to anything, you got to do it. Regardless of strategic consideration that his lawyer concludes weigh against such decision, the defendant who wishes to testify must be permitted to do so. You got to do process right, but only you can do it. The attorneys can't do it for you. The burden of ensuring that the defendant is informed of the nature of existence of the right to testify is a component of the effective assistance of counsel. Ding, 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 right there. The only burden they have is to simply tell you that you have the right to one thing or the other. And that's it. Once they do that, they've effectively assisted you as counsel. We'll read that again. The burden of ensuring that the defendant is informed of the nature and existence of the right to testify is a component of the effective assistance of counsel. That is it. The only burden they have to you is to tell you, hey, bud, you got the right to do this, you got the right to do that. Outside of that, they can do whatever else they want. You've just wasted your money thinking they're going to save you. To establish a claim of ineffective assistance of counsel based on violation of his right to testify, a defendant must satisfy the two-pronged Strickland test, including showing reasonable probability that his testimony would have altered the outcome at trial. How can it alter the outcome at trial? Testimony can be written or oral. If you haven't put any evidence in and haven't objected to anything, which an attorney would not do for you, you can't prove this. There you go again, being set up for failure. Section 2255, which by the way is a section of 28 USC. Section 2255 provides that a petitioner can obtain an evidentiary hearing on his claim unless the motion and the files and records of the case conclusively show that the petitioner is entitled to no relief, meaning you've exhausted your remedy. A 2255 motion does not entitle petitioner automatically to a hearing, meaning we don't owe you shit. Why? Because this is a similitude of a habeas corpus. And even then, if you do a habeas corpus, you still have to bring in the law and come right. You have to deny things on record, preserve the record, bring in affirmative defense, bring your evidence in support of that habeas corpus. What's going to compel us to issue that writ? To tell somebody to come provide the law to answer for why they're holding you. So 2255 does not strip the district court of all discretion, meaning how they feel and what they want to do, to exercise their common sense, meaning it's common sense. If you're doing 2255, it's common sense for us to construe it however we want. We're not obligated to it. It's not a constitutional right. It's a statute that we created and we regulate. And because of that, we don't have to hear it, especially if you're not coming right. In particular, no hearing need be granted when the allegations merely contradict the record or simply conclusory. So you're saying that man or woman did not effectively assist you? Where is the evidence of that? To warrant a hearing, the motion must set forth specific facts supported by competent evidence. There you go, evidence. Raising detailed and controverted issues of facts that, if proved at hearing, would entitle the petitioner to relief. General and conclusory factual allegations which are based upon mere suspicions and conjecture will not suffice to necessitate a hearing. The record establishes that petitioner does not dispute. There you go. You have to deny, object, refuse, dispute anything that might be detrimental to you. On the record, you have to. Now they're using it against you. The trial counsel informed settler of his right to testify, having discharged their duty by advising settler. Right, discharge right there. The performance we spoke about up there has been discharged. They're not obligated, they're not bound by it, they're not having a burden. Why? Because all they did was their duty by advising settler, the one who hired them, that he had the right to testify on his own behalf. That's all they were liable to do. To give you legal advice. That's it. All those paperwork and showing up for court date and giving character witness, which is, by the way, inadmissible, unless you as a defendant are using it against a plaintiff as a defense. But character witness by a third party for you doesn't have a standing, is not admissible. And that's all the attorneys are going to do. They're going to say this guy has a very nice teeth, he has a nice wife, he cuts his neighbor's grass for them, he's such a good neighbor, he graduated this college, he has 3 children, he makes this much money. That's all the character witness they're going to do for you. They're not going to do any affirmative defense. They're not going to deny anything on record for you. They're not going to preserve any records. They're not going to bring any constitutional claims for you. You do that. Having discharged their duty by advising settler that he had the right to testify on his own behalf. Right there, that's all they're liable to. They're discharged of their duty. They owe you nothing more. Once they've told you that you have the right to do this, that's it. It was not objectively unreasonable to advise settler that, in the view of trial counsel, taking the stand was not advisable tactical choice. Meaning, once they tell you, hey, you have the right to do it, but we can then say, hey, well, although you have the right to do this, based on our professional standard of what is known that we do in this field, you shouldn't do that. Although you have the right to do it, but you shouldn't do it. Nor does and he didn't object to this. He didn't dispute to this. He didn't dispute it. Nor does the petitioner explain how settler was prejudiced by the decision not to testify. In the course elocution of the defendant during trial, the court confirmed that settler understood he had the right to testify. Then they used the court record against him. All right, Mr. Seller, do you understand, sire, that you have the right to take the stand and testify in your own defense of the case? Yes, he responded. Now, have you discussed with your attorneys whether you wish to testify in the case? Yes, he responded. Right there, he just waived his due process right to be heard. So they already letting you know, if you do a 2255, we don't even want to hear you in the first place. And we can exercise our discretion not to. But we'll play the good guy and say, hey, look, you fucked up. Because we told you, look, you can be heard once. You could have prevented it. And if not, you could have disputed it. So now this decreases your likelihood to even begin with it because your claims are just frivolous. There's no need for us to hear it. So bye-bye. That's what this is right here. Seller's petition does not dispute that he understood he had the right to testify on his own behalf, which is the hearsay exemption for a character witness. Right there. They're telling you. And that he had discussed that decision with his trial counsel. In fact, Seller's declaration states that prior to the last day of trial, he not only understood that he had the right to testify, but he expected to exercise the right. And during the lunch break prior to Kurt's allegation about the right to testify, Seller had further discussions with his counsel about the decision to testify. During those discussions, our counsel informed, now this is quote unquote what he said, informed Seller that there was no need for him to testify because they were certain that we as warned and there was no need to say anything. That's what he said. They're using his words against him, which is in fact admissible. The record is clear that trial counsel advised Seller of his right to testify, which was all he was required to do to meet his burden of performance as a legal counsel. And nowhere does Seller allege otherwise, and he didn't object to it. Seller's disagreement is instead a disagreement over tactic, which he is not a professional to make such a decision. Seller contends that he had doubt about counsel's recommendation that he not testify, and also contends that he now wishes he had made the opposite choice, but he does not contend that his counsel failed to explain to him that he had the right to take the stand, which is all that you're liable to do. To tell you that you have the right to do one thing or the other. So long as defense counsel has advised the defendant of his right to testify, defense counsel does not provide ineffective assistance by advocating, even in the strongest terms, that the defendant not exercise the right. Right there, all he or she has to do, that attorney has to do, is tell you, hey bud, you have the right to do this. But even if it tells you, yeah, you have the right to do it, but don't do it, it's a tactic. They're not doing anything wrong. They don't owe you anything because they've advised you that you can do it because it's your right to enforce. Now, whatever they tell you based on what they do in their everyday legal profession, that's them. But you still have the right to do it. And it's up to them to not take that right from you, but to actually just inform it. But they can't enforce it for you. Counsel has wide latitude, meaning they're your God. Again, they're using this word. They're letting you know, look, the moment you hire them, you have no saying in anything. That attorney runs you and your life. They're using this word wide latitude as a qualifying phrase for a very good reason. In making tactical decisions. And whereas here, such decisions are made after thorough investigation of law and facts. Those decisions are virtually unchallengeable. You can't say anything else. But what are the law and facts that's thoroughly investigated? The only law and facts are thoroughly investigated when attorneys are involved are the things that's against you. Because an attorney is not going to put any law and facts that's benefiting you. So what's on the record is only what's going to be observed when you do any petition or appeal, whatever it is you're doing. So he makes basically the same contentions and they basically shut it down. So if it wasn't clear before that attorneys owe you nothing, and once they screw you over, you can't come back and say, well, because I gave this guy amount, I felt entitled. So he should have done this for me. So he didn't do it properly. In your mind, you thinking you gave him this large sums of monies, so he was supposed to do something for you, and he didn't. So now you can come back and talk about, well, he didn't assist me legally, properly, ineffective assistance of counsel. Wrong. He doesn't owe you anything. You can pay him $20 billion. All he's liable to do is tell you, hey, you got the right to do this. But, no, since there are more bonds involved and I get commissions for it and whatnot, don't do this, okay? So that, they're not going to tell you that, but they're just going to give you legal advice based on their standard of profession. Whatever the case may be, if you're trying to do a habeas corpus or any similitude of habeas corpus, do your best to not bring ineffective assistance of counsel in the case, because that man or woman is simply doing their job, which is to hold fidelity to the British Accreditation Register membership, and to basically tell you, hey, bud, you have the right to do this thing over here, but if you want, you can do this. That's all. Don't blame him. It's your fault, because it's your right, and it's your obligation for you to know it and to enforce it. Just a little food for thought. Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people to make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust-related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W-8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not, the intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that our YouTube are synonymous with things that are for the birds. One of the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways when it comes to the Express Trust 98 number. We went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More on discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how and importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference in the truth of legislative fact compared to adjudicated fact and what it really means when it comes to judicial notice. We speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies. Tax evasion. We show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We're speaking about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. We're speaking about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort. Speak about speak about trust. Speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right, the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight, beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things of nature and how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.